Ron.
Yeah.
Why didn't you say it the first time I said Ron?
Because it's pronounced Aaron.
You done messed up, Ron.
Ron and my lawyer friend Zach are here, everybody. Welcome and welcome, Zach.
Thanks for having me back. Welcome, everybody.
My pleasure. Guys, we got to get this party started right. If you're not already subscribed to my lawyer friend Zach, jump over to his YouTube channel and subscribe. You can find him at Your Lawyer Friend Zach. And guys, if you think you're subscribed, you might be surprised to find out you're actually not. YouTube has been platform-wide auto unsubscribing people from channels, probably to make sure that people are subscribed to channels they really want to watch. I don't know. I don't. It doesn't make a lot of sense to me, but what do I know? I grew up in a cult. What about you?
I don't know, but I did not grow up in a cult, but I don't know either.
Okay, look, we're here to talk about two specific subjects, and Zach, I'll tell the viewers what the two are, and you let me know which one you want to talk about first.
Sure.
So, the first one is Danny Masterson, the huge amount of trouble it looks like he's in, the huge amount of trouble it looks like his lawyer, Kate Mangles, may be in for lying to the judge, to the court about misrepresenting that Danny had complied with the terms of his bond. And even the terms of his probation report requiring him to relinquish, to sell or destroy his weapons. Not only is it clear he did not do that, but it's clear that his attorney misrepresented to the court that he did. That's subject number one. Subject number two is the ruling from a judge just 2 days ago that Jane Doe can move forward with limited discovery regarding the unconscionability of Scientology's internal arbitration. Which one of these do you want to tackle first?
Let's just take them in order. Let's start with the Danny Masterson guns and Kate Mangles, and then we'll tackle the discovery issues.
All right. Okay. So, what do you want to say about the Kate Mangles situation? Is there anything I've missed here?
So, obviously, if Danny does, if the federal government or the state of California decides to prosecute him for weapons violations, weapons charges, no government anywhere, even in states that have really owner-friendly laws, they don't take weapons charges lightly. But the bigger issues with the attorney, I've said on your channel before, and I think you said it yesterday or the day before, lawyers don't have to raise their right hand to tell the truth every time they go to court. We do it one time when we're sworn in as a member of the bar to practice law. And we're considered an officer of the court, just like the bailiff and the court reporter and the judge, right? And so if I put my name on a legal document and submit it to the court, and I sign it and submit it, I'm putting my license at risk. And I'm submitting that under the penalties and pains of perjury. I also have implicit duties, both implicit duties, meaning I've done my due diligence, but also explicit duties set forth in the rules that govern lawyer conduct that says I've done my due diligence. I'm submitting this based on good faith. I'm submitting it, and the information in it is contained in it as a result of the research that I've done. And clearly, she hadn't done any of those things. A cursory review of the gun registry. If I'm in that situation, my client says I took him to the local county sheriff's office, local police department. There's a form that they fill out that says Bob Smith surrendered the weapon to us this day, and it's in line to be processed and destroyed. Then after it's destroyed, they get a slip from wherever they take it to destroy. It says this gun serial number such and such has been destroyed. She could have, with 10 minutes of effort, generated the paper trail. Or more importantly, she would not have been able to generate her paper trail because the paper trail didn't exist because they weren't destroyed, even though she said they were. If failure to do due diligence before you submit a court pleading, even for something that from a legal perspective, this is a very nominal thing. He's still in prison. He's going to prison anyway. It would have been a much bigger thing had he been found not guilty, but he was found guilty. He's going to prison for a long time. And so if he gets additional years or something, I guess good, bad, and different. But if I'm her, I'm not sleeping real well right now. Because the folks who are in charge of bar discipline are very likely going to investigate this. And I would be very surprised if they didn't at least send her a notice of an investigation is open and you have the right to respond. Each state does it differently, but essentially you have the due process clause of the Constitution still applies. I get notice that I'm being investigated and I have the right to respond to the allegations. So I fully suspect that they're going to investigate that. And the attorney discipline can be as little as a private reprimand where nobody knows you got in trouble, all the way up to being disbarred, private reprimand, public censure, suspensions, fines, and disbarment.
Is disbarment considered like, I mean, it almost seems to answer itself. It seems to be an it's an extremely severe form of punishment.
Yeah.
I mean, what's your opinion on the likelihood that, just given the facts that we already have, this could end up in something like disbarment?
I certainly suspect that there will be a suspension of some sort. So a lot of times you're not going to get, unless it's something super egregious, like you robbed a bank. Disbarment doesn't often occur on the first offense. It's after you have a history of offenses. And I don't know her attorney conduct file. I don't know if, for all I know, she may have a spotless record and this was just a really bad choice on her part. Probably not going to get disbarred for that. But if there's a history, even if it's just these little ticky-tack things, if there's a history of this, then they're certainly like, listen, you can't just keep making little mistakes and get off the hook. And by the way, this isn't a little mistake. You filed a legal document with the court that contained untrue, dishonest information. If you're going to lie about the gun, are you going to lie that you talked to your client and they agreed to the plea agreement? Are you going to lie that you tried to serve this person and couldn't, so now you're trying to get the easy way out? If you're going to lie about that, what else are you going to lie about? And that's sort of the position that the state will take.
So help me understand something like this, because I I know so many people will be watching this and go, what are you talking about? Lawyers lie all the time. They lie for a living. They're constantly misrepresenting the facts, twisting. So how do you respond to people who feel that way?
So first off, you're sort of halfway there. The people who feel that way. I recognize, I understand where you're coming from. But we as lawyers are given broad latitude in how we present our case. This was the worst car wreck you've ever seen. My dear old grandma client was hit so hard her life's never going to be the same. And the other attorney stands up and says, it's a fender bender. They fixed it with a hammer and a hot gun. Right? Both of those are probably extremes. Mine's very extreme and the defense is very extreme. Somewhere in the middle lies the truth. But that's us lawyering, right? We'll argue over the word. And so if somebody asks me, what does a word mean? As a lawyer, I'll say, well, you define it. Let's go with your definition. Whether I like it or not, I can change it later. But that's lawyering. That is not misstating a material fact or submitting something that is untrue. The way I examine a witness, I'm given broad latitude, but even then there's rules, right? People object and they get sustained because it's an improper question or bad evidence or something. So there's sort of a lot of moving parts in it. But the one thing I can't do is I can't sign my name to a document that I'm swearing and affirming under penalty of perjury. Sorry about the light, guys. The penalty of perjury that it's accurate when it's not. I mean, the court has zero tolerance for stuff like that. Because if a criminal defendant stands and tells a lie, they're going to get prosecuted for perjury.
Right.
She committed perjury.
So here's another one I really want you to opine on. Because to me, this next question kind of relates to the egregiousness of what, if I'm being gracious, I'm going to call pure carelessness and ignorance. Okay. Mm-hmm. The evidence that I used to prove that Kate Mangles was misrepresenting the facts to the court was literally the evidence attached to her own motion.
Yeah.
Like, she clearly did not understand what the evidence she was attaching said. It's hard for me to believe that she knew this report would expose her misrepresentation and she included it anyway.
Well, here's the thing. So there's some things they have to do, some things they have to file, of course, in this case, right? But it is not a far stretch to imagine that a lot of state court judges, especially because they don't have all of the back end support, the court clerks and the lawyers helping them, that like a federal judge does. It is possible and foreseeable that if a state court judge is overwhelmed with matters on their docket, they look at it and go, oh, she looks like he surrendered his guns. Yep, here's the form. And they just sort of rubber stamp it as a part of routine practice. A judge has an obligation to read everything in detail, but I also understand and I'm willing to accept the fact that they may not have time to do it sometimes. And she may have just rolled the dice thinking, hey, I've seen Judge Almeida before. The judge is always super busy. She sort of rubber stamps this as a matter of due course and got caught with her hand in the cookie jar on this one.
So where does the bar or just legal peers, where do they come down on the issue of the judge should have caught it or the attorney shouldn't have represented it?
Well, in this case, with especially since she redacted out the name of who we believed to be Jordan Masterson, but it ultimately was not. It was
Mike Shupin.
Mike Shupin from Tennessee / Oregon / wherever he might be located at the moment. The judge can reasonably rely on that redacted, especially if they're trying to preserve the identity of the person who is trying to legally sell the weapons, because there are people in this world who will go and try to rob people who are, that they know are trying to dispose of firearms or something. So I could absolutely believe that, I'm going to redact this. The judge says, okay, well, we know who that is. No big deal. But in this case, she redacted it, but redacted information and then led the court to believe that the name she redacted was Jordan Masterson when it wasn't. That's where the issue is. It's not just the fact that she said they were destroyed and they weren't. It's the fact that she presented something and tried to lead the court to believe it was something different than it actually was.
Right. What about the form where she says, look, here's a form that shows all the weapons that show up with this serial number. You can see that Danny owned this weapon with this serial number at this date. And then at this date, that same weapon with that same serial number was destroyed. But you look at that report and you go, they're two different weapons. Is she allowed? What happens if Kate Mangles shows up and says, I'm so sorry. I didn't understand that the serial numbers wasn't the whole serial number and that those were two different weapons. Like, I mean, does she have any latitude to say I made a mistake?
Because what she should have done was consulted with an expert, whether that's an FFL holder or maybe somebody with the ATF, something like that. Consult with an expert and then bill your client that fee. Like if I go and incur a cost as part of the representation of my client, I pass that cost along. I hire an expert. That expert charges me $200. I put that on my client's invoice. I have to go and hire a court reporter to take a deposition. That deposition costs $1,000. I bill that and put it on my client's invoice. She absolutely had an obligation to go and consult an expert, get an expert opinion, and then she can rely in good faith on that expert opinion. I don't claim to be an expert in firearm law, but here's the expert that I consulted with, and here's their written opinion that I have complied with the terms and conditions of this court's order. She didn't do that. So at the very least, it's legal negligence and is or legal malpractice, in my opinion, but it also raises conduct issues from a bar discipline perspective.
Amazing. I have one last question on this specific topic, and that is, help me understand the lawyer's ability to actually issue orders and demand compliance from her client. And here's what I mean. There was a point there where Danny claimed to have no knowledge of the location and the whereabouts or the ownership of these, let's just say 8, 9, 10 weapons. And then after that, he gave his brother, Jordan Masterson, power of attorney to control these weapons and dispose of them. That power of attorney was only going to last for 30 days. Now, the fact that he gave his brother power of attorney to do this kind of implies he believed his brother was going to have the knowledge and the ability to dispose of these weapons. So the time is ticking. 30 days are ticking. If I'm Kate Mangles and it's my job that I'm going to have to represent to the court that this issue has been resolved, I'm thinking to myself, I'm going to be checking in with Jordan. Hey, Jordan, where's these weapons? Where's these weapons? Where's these weapons? That power of attorney lapses. 30 days goes by. Nothing's happened with the weapons. And then when I find out that this guy, Danny's BFF, Mike Shupin, is in possession of all these weapons, and Danny's claiming not even to live in California, I'm going to go, say what? Who's got the weapons? Where are they? You're driving them to Oregon to do what? Oh, hell no. You drive those weapons to LA. You renew the power of attorney for Jordan Masterson. You say, Jordan, you take these weapons and you sell them. We're not doing a little dance here for the court. Mm-hmm. So what is she allowed? I mean, what power does an attorney have to say, you're going to do it this way because it's kind of my ass on the line?
Well, I think you're exactly right. And the power there is significant. Thou shalt comply. And if you don't, I will fire you as my client. A client can fire an attorney and an attorney can fire a client. Mm-hmm. So absolutely they can fire the listen, I've asked you, I've requested, I've asked nicely, I've commanded, and if you're not going to do it, you're going to have to find another attorney who's willing to put up with this. I'm not going to put my bar license on the line because you're a goober. I'm not going to do it.
I just don't think it's a coincidence that Kate Mangles happens to be the daughter of David Miscavige's attorney, and that Kate Mangles just happens to be the one covering up for Danny Masterson. I'm sorry. It's way too much of a coincidence for me to believe it's a coincidence.
I think you and I agree on that.
Okay, so the second issue, discovery in Jane Doe versus David Miscavige, Church of Scientology International, RTC, Bridge Publications, and Gavin Potter. For the first time ever, discovery has been granted, limited discovery. By the way, limited discovery is what was requested in the first place. It's not just what was granted. Into the unconscionability of Scientology's internal arbitration. Scientology is going to have to turn over records detailing the process of its internal arbitration. And it is my belief that in this effort, the court is going to see for the first time ever that there is no such thing and there is no actual procedure for internal religious arbitration. It's completely horseshit. It doesn't fit any normal standard of arbitration. It's completely unfair. What are your thoughts on this?
So I think that the significance of this order cannot be overplayed. For one, this is incredibly significant across the country. I mean, you know, a lot of judges, and we've talked about this before. A lot of judges say, "Hey, I disagree with the law, but here's what the law says." Well, this judge got creative and found a way to do this. As you know, and as you know, not probably, it's definitely better than I do, as you've articulated. Anything that exists in the organization exists by virtue of Hubbard policy. Mm-hmm. And if the policy letter doesn't exist, the thing doesn't exist. Mm-hmm. Part of this discovery process will allow them to demand production of every policy, every Hubbard policy, every whatever, wherein Hubbard created the existence of this thing. And if they, right, because I'm sure somewhere, and you know better than I do, somewhere there's a document somewhere that says, if I don't say it, it's not a thing, right? And this former Scientologist knows that exists and may even have a copy of it, but can certainly produce a copy of that. Okay, right. Cool. Now that we know this exists, you, various defendants, have an obligation to show me the Hubbard policy or other document that creates the existence of this. And without it, there's a great argument that it doesn't exist.
That's right. Because, and I'm not sure how the courts would view this, but in my opinion, Miscavige himself cannot just write up some edict and say, this is now Scientology scripture, because Scientology claims all quote unquote Scientology scripture is based on the works of L. Ron Hubbard.
Right.
And L. Ron Hubbard never said anything about internal arbitration. Mm-hmm. And one of the things that I want to emphasize here is the subject of unconscionability. And I want to give my understanding of why this is an important thing for the court to focus on. In the past, in earlier lawsuits, when the plaintiffs, the former Scientologists, have argued that the arbitration process is completely unfair and should not be enforceable, Scientology has actually argued that's an issue for the arbitration panel to take up. The court's not allowed to decide if arbitration is unfair. Only the arbitration panel can decide if arbitration is unfair, which of course seems crazy to a normal individual, right?
Yeah, it's a circular argument.
It is a circular argument. And according to how it's been explained to me, this thing of unconscionability is what will determine if the court, the judge, is the one allowed to decide if arbitration is unfair or unwarranted. And that's why the judge in this case has granted the discovery of, okay, well, we have to take up the issue of unconscionability. He's basically saying, before I can rule on whether this should go to arbitration, I have to resolve this issue of unconscionability. So show me the policies, show me the procedures. And Scientology simply isn't going to be able to do that because there are no policies and procedures.
Exactly. And I think we need a definition, right? We're throwing the term around. Most folks know, but right, the general definition of unconscionability in a contract, which is what this is. This document these people sign is a contract between themselves and the various religious organizations. All right. The terms are so extremely unjust or overwhelmingly one-sided in favor of one party to the detriment of the other that the court says this can't stand. It violates social norms and the basics of morals and ethics in society. We're not going to allow this to stand. Right. So, I mean, to the point that, like, for an extreme example, a payday lender is almost an unconscionable contract because they charge thousands of % interest, as opposed to a bank or credit union may charge 6 or 8 or 10%. right? That's almost an unconscionable contract. And in some jurisdictions it is. And so that's what the court has to evaluate. Inherently, the body that may be established to adjudicate the dispute, in this case, the arbitration panel, cannot itself determine if it is fit to arbitrate the issue. It requires necessarily a disinterested third party to determine the applicability or unconscionability of the existence of this panel, of this arbitration system.
Right. Assuming that some of the people in the chat are correct, can you slightly push your mic away from your mouth to get our audio levels a little evened out? All right,
course.
let's see how that goes.
Yeah, of course.
Now, here's what's interesting, because there is another lawsuit right now. Baxter, and Paris versus David Miscavige, Scientology et al., where the judge very reluctantly said, I'm sorry, this has to go to arbitration. And he never granted discovery into the unconscionability point. And yet in that case, the plaintiff's team said to the judge, can you please grant us I'm going to get the word right, an interlocutory appeal?
Interlocutory
Appeal. And that's basically like, please, judge, even though there's nothing to appeal yet, can we put a pause on this thing and appeal this one decision to the higher court? And the judge basically said, yes, absolutely. This is something upon which judges and courts could easily disagree, and he did grant that appeal. What is your opinion on why he would go to such lengths as to allow his decision to be appealed, but he never granted discovery into the unconscionability issue of the contract? I wonder if the team never asked for discovery. I'd have to review that. Yeah,
one, they may not have asked for discovery, but two, the judge says, listen, this is the way I interpret the law. And he kind of implied, I hope I'm wrong. I hope I got this wrong. But so the way interlocutory appeals work is normally you can't appeal something until you get a jury verdict or an order of final determination, like a judgment, right? You owe $150 million in Rudy Giuliani's case, right? Whatever. He can appeal that. But if there's a discovery issue that could affect the outcome, listen, our ability to conduct or not conduct discovery will affect our ability to prove up our case. So you take that issue to the appellate court, because then 2 or 3 or 4 years down the road, when this case is finally adjudicated and wrapped up and closed, now we have to go back, and if in fact the judge was wrong, we have to undo 4 years worth of work and 4 years worth of money spent and time spent. So they're going to go and get this issue resolved because it is a key issue in the case, and whatever happens, you take it from there.
Okay, I'm really fishing on this next question.
Okay.
The Baxter Paris case is being tried in federal court in Tampa. The Jane Doe versus David Miscavige et al. Case is being tried in state court in California. The fact that this limited discovery has been granted in this case in state court, help me understand, is there any way at all that this decision or the discovery that comes about as a result of this decision could in any way impact what's happening in the case that's being tried in federal court in Tampa? So the federal court would never. So first off, no other courtroom in the same building in LA would actually be subject to following this court because it's not an appellate court. It's only binding on the parties. But let's say the California appellate system upholds that. The folks in federal court can't rely on that. It can't require the Tampa court to be bound, the Tampa federal court to be bound by it. So it's not, but it is what we call persuasive authority. Okay. Judge, this issue has this exact language, probably word for word, has come up in a case based on very similar facts in a different jurisdiction. And we believe that the law that you are limited to follow, the law that you have to follow, has not properly and squarely addressed this issue. So we would ask you to review and apply the case of this other state. We think it's persuasive. The judge doesn't have to follow that, but they're absolutely going to cite that law and lean on that law if they get a favorable outcome. I like that you said it that way, because that's actually more where I was going with it. Not whether he'd have to, but whether he'd even be able to point to it or consider it, because it was pretty clear that the judge didn't want to have to find the way that he was finding. He thought it was ridiculous, but he also thought that according to the law and the precedents that he had to follow, he basically begrudgingly said, "I'm sorry, this is the way I think I have to rule." Yeah, absolutely. I can cite out of the jurisdiction and out of the appellate system that binds that court.
The court doesn't have to follow it. But let's say, for example, like we see this, I see it fairly often. Let's say 15 states do it one way, and the rest of the states are silent, and my state hasn't figured it out. I'm going to go find all 15 states and find a bunch of stuff from those 15 states and pile it into my brief and say, look at what all these other states are doing for similar cases, and their laws are very similar to ours. This issue hasn't been decided by a binding appellate opinion, so let's rely on all the wisdom and all the experience of these other states to help us come to a resolution.
I love it. Guys, we've got about 2,800 people watching live right now. If you are not already subscribed to my lawyer friend Zach's channel, find him on YouTube at Your Lawyer Friend Zach. All his videos are as good as, what we're talking about right now. Okay. Anything else that we want to say on this?
It's going to be interesting, that discovery. If they haven't already, I absolutely suspect that one or more of the defendants will seek to seal the discovery. When something, I mean, if I'm representing them, I'm absolutely going to I don't know that they win it, but I'm absolutely going to try. The reason I don't think they can win it, people who are in their organization already have access to that information by virtue of paying for the coursework.
Oh, that's a good point.
Now, if there's something in the confidential levels that would be responsive to it, there's an argument that, based on our doctrine, our religious belief, this has to be sealed from those who aren't prepared to receive the information. See also Xenu, right? The confidential OT levels. But if it's something that's not part of the confidential OT levels, it's something the public can just write a check or put a credit card number on file and buy access to. So I don't know that they're going to win it. I think they're absolutely going to seek to seal it. And just so the folks understand, when something is sealed, it doesn't mean from everybody. It means from the public. The judge can see it, and all the parties, the attorneys, the litigants, everybody involved in the case can see it. And even expert witnesses. I hire an expert witness to come in. That expert witness would have to sign that they understand they're subject to a protective order, but then they could review it, but they can't discuss it outside the confines of the court.
Right. I'm going to try bringing my mic closer. Zach, does your mic have a, what is it called? Not a DSLR. What is this? The better cable other than USB?
I've got an XLR, but I can turn my audio down.
No. Don't change anything. Don't change anything.
Okay.
Is the fact that your mic has XLR and mine has USB, what might that give your audio? Might that just make your audio levels better than mine?
That, and I'm a loud talker.
Well, I'm a loud talker too.
Yeah, that's true.
Okay. Someone pointed out to me that just because something comes up in discovery doesn't mean a jury's ever going to be allowed to see it. And
That's true.
I got to tell you, on my end, I don't think that matters here. On my end, I think what's relevant is that the court is going to have the opportunity to rule on the unconscionability of this procedure. I don't even think it matters if it gets in front of a jury.
Well, this issue can't go to a jury. This is what we call an issue in equity, not an issue in law. This is an issue in equity. Issues in equity never go before a jury anyway. It is the purview of the judge, the court, to determine the conscionability of a contract, not the general public. Right. Because that's an issue sounding in equity. An issue sounding in equity must be adjudicated by the judge, but issues in law can go to either a judge or a jury. Whether or not these people, Valerie Haney was trafficked, is an issue at law for a jury to decide. Whether or not the contract she signed is unconscionable is an issue of law sounding in equity, so it has to be adjudicated by the judge. The jury's never going to see it anyway. They can't see it. The judge is the only person who can adjudicate that if it's an issue in equity.
Okay. All right, real quick. Let's jump through some of the super chats here. JL, if Danny lied to lawyer about guns, would she be responsible still?
Maybe. It depends on how much due diligence she did. But it would be her burden to prove that she did her due diligence. Here's all the people I called. Here's a copy of my phone log. Here's the notes that I took. Here's the documents that I generated. So, but the short answer is, yeah, she would probably be responsible if she did not do her due diligence. And in this case, it doesn't appear she did.
All right. I'm not sure I know what this means, but #retire. Zach, see you at 2030 for your Saturday night chat from Gary Mackey. Do you know what this means?
So there's a running gag for the folks who are my most active contributors. It's the #retire Zach fund. They want me to get to a revenue stream such that I can quit my full-time job and just talk about law stuff on YouTube for a living. So that's sort of a running joke on my channel.
Hell yeah, I love that. That's a great thing. We can get there easily. I know you can. I'll help you. I'll do what I can.
Thanks, Aaron.
Laura Waldy, thanks for your analysis, Zach.
Thank you, Laura.
Okay, Dave Owens. So much of what has kept lawsuits at bay is the arbitration clause in the documents signed by all consumers of Scientology. Does this basically knock out the foundations of the contract?
So first, that's a fantastic question, Dave. I love questions like this. This goes back to what Aaron and I talked about just 2 or 3 minutes ago, where the federal court in Tampa, for example, Valerie Haney case, they don't have to follow. They're not legally required to follow the order of this LA County district judge, but it's persuasive authority, and it certainly is. It's even if it's a small shovel blade, it's a shovel blade chiseling away at the foundation of this giant shield that has protected the church. And you don't knock it down with one shovel, but one shovel leads to 2 shovels, to 3 shovels, to backhoes, to wrecking balls.
I love it. I love it because it's true. If the more courts issue decisions that these contracts are unenforceable because the procedure that Scientology claims the contracts stipulate are unconscionable. It's that is why what's happening here is so important, is because of the direction it is heading of potentially invalidating these contracts wholesale. That's
Yeah, exactly. And it's sort of like a snowball. You get one favorable opinion, and then some court somewhere relies on it, and you get 2 favorable opinions, and then suddenly you have this momentum where everything is sort of moving in this same direction, and that's the way the law is trending. And then more and more judges who are hesitant to jump on that snowball, now the snowball's big enough with enough momentum, and they have enough appellate court support, they start jumping on this and following it.
Yeah. Okay, this is a good one here from I Have Questions. What stops Lil Davy of the Fake Space Navy from just writing it? The arbitration procedure. I know he isn't supposed to add anything, but what would stop him? I have an opinion.
Well, I mean, assume if he handwrites it and he produces that document, we turn it over to a handwriting analyst, and he says that's not L. Ron Hubbard's handwriting. If he were to write the document on a computer, they have every right to ask for the discovery of the metadata. Who modified it? Who edited it? Who changed it? When did they change it? Who was logged into the computer at the time? What account was used to modify it? And it'll also sort of similar to like track changes in Microsoft Word. They can see the individual changes that were made to the file. And so that metadata exists. So if he tries to do something on the computer, they can request that metadata and see who did it.
There's another answer that I have, which is Scientology's attorneys in the Luis Garcia case and in the Valerie Haney case have already pleaded to the judges that the committees of evidence policy letter is the procedure for an arbitration. So if Miscavige comes up with, oopsie, look what I just found in a desk, L. Ron Hubbard actually, buried under my Webster's New World Dictionary, I found L. Ron Hubbard's secret memo about the arbitration procedure. It's like, the attorneys have already failed to argue that there is any actual arbitration procedure other than the committees of evidence policy letter. And so one of the things that Scientology's in the ruling, Scientology is going to have to explain or prove is the committees of evidence policy letter the procedures for a punitive procedure or an arbitration procedure? Because arbitration is not supposed to be punitive, and yet a committees of evidence is punitive in nature.
Well,
in Scientology.
And this is where the lawyers are going to have themselves a problem here, I think. On the same issue across multiple jurisdictions, you can't make multiple arguments because any judge worth their salt is going to say, listen, I know you're in federal court in Tampa in front of me, but why did people in your position argue differently in California? Which one is it? Right here in front of me with your bar license on the line, you're going to tell me which position is yours. That's the one you're going to be bound to.
Right. Guys, we got over 3,000 people watching now. If you're not subscribed to my lawyer friend, Zach, go subscribe to him at Your Lawyer Friend, Zach. I guess that would have been nice if I didn't still have the super chat up there. Okay. Julia O'Connell, thank you for all you do.
Thank you, Julia.
Russ T, are those guns in storage in Oregon actually surrendered, or are they just stored? Excellent question, Rusty. They are just stored. They're not sold. They are just stored. I verified that with the shop owner himself. I got a copy of the contract. I can tell you that Mike Shupin, one of Danny's BFFs, is claiming to that gun owner that Mike Shupin, is the owner of these guns, but he's not required to provide any evidence of that because he claims that Danny either gave him or sold him these guns in Tennessee years ago. And apparently, and you people who know better can correct me in the live chat or in the comments. Apparently, if such a thing were to have occurred in Tennessee, you're not required to show any paperwork. Does that sound right?
Well, I mean, is if the transaction is between two non-FFL holders and it's a transaction involving guns that are otherwise legal, like they're not trying to sell a full auto or something,
Yeah.
there's not required to be a paper trail. I mean, it's perfectly legal to sell guns out of the trunk of a Cadillac.
Just not in California, though, I guess.
Yeah, you know, in Tennessee, that's a fairly conservative state with fairly with fairly owner-friendly gun laws. Not talking about the politics of it; it just is what it is. So that's absolutely something that would do. I mean, you know, you go to any garage sale, and somebody's always selling grandpa's shotgun and daddy's pistol and all this other stuff, and those aren't required to, unless somebody there is a federal firearms license holder. There's no paperwork required to do that. The only paperwork is required at the FFL level, or if it is the transaction involving a weapon that is registered and limited by federal law, such as full auto, burst fire, suppressors, and silencers.
Yeah. And so what's interesting is that back in the day, whether it was 3 years ago or 5 years ago, I always kind of forget, when Danny was first ordered, because when Danny was just on trial, he wasn't required to actually sell or destroy his weapons. He did just putting them in storage at a gun shop would have been fine.
Yes, he just had to dispossess the actual availability of them.
But what he wouldn't have been allowed to do is just give them to a friend.
With no paper, right? The burden would be upon Danny Masterson to show he complied with the court order, and simply saying I did it is not enough. The court follows the Missouri rule, the show me rule. Show me what you did. Well, there's no paperwork to show the transaction. So,
right. Tom Working says, have you ever thought about doing your own South Park, like a humorous form of the basics of what your message is about? Good propaganda. Tom, I guess the short answer would be no, or the other short answer would be, this is my own South Park show. Welcome. Marsha Bentley, how can you be held to a contract you started signing when you were just a child? In a cult, you are never exposed to real world laws or ethics to know better. Marsha, I hope you're doing okay. The answer is that, and correct me if I'm wrong, Zach, if the contracts that any of these Sea Org members signed were only signed when they were kids, we wouldn't even be having a conversation about it. It's the fact that once they reach the age of majority, they continue to sign the contracts, because you're required to continue signing the contracts. You're not even allowed to read them. You're not allowed to keep a copy. You're not allowed to get legal advice. And this is where the courts have a hard time stepping in and deciding whether they're enforceable or not. And that's why so many of these decisions have gone Scientology's way, and so many of these suits have been thrown into arbitration.
And Aaron, this is where I think you've addressed this in another video, that every time you begin another course, whether it's the Purif or whatever, anytime you start a new particular course of training, you have to sign this document again. So you signed it at 15, you signed it at 17. Those technically don't count. But then you signed it at 19. That one does count. You are the age of majority. But for your sole focus at that point is, I'm trying to move towards the state of clear and move into the confidential OT levels.
Right. Yep. You're doing pretty good with the language, I gotta say. Yeah. David Miscavige. It's a great day not to be me, a Space Navy gimp.
That's funny.
Welcome, Dave. I hope you have a good night at the Shrine Auditorium, where you're going to meet up with William Good from Streets LA and Jessica Palmadessa of TikTok fame. It's going to be a great evening, guys. Blake Reed. Welcome, Blake. What's up, Zach and AA Ron? Hey, Zach, what was your most difficult case as a lawyer, if any?
Oh, I don't know that I had any that were terribly difficult from a factual perspective. I did have a case of an unborn child that was delivered, and then due to the negligence of the medical staff did not survive the childbirth process. And my wife was pregnant with our oldest at the time. So that was difficult emotionally for me to manage that case, but we were able to get a really good recovery for those young parents.
Wow. Guys, we got over 3,100 people watching live right now. If you're not subscribed to my lawyer friend, Zach, go subscribe at your lawyer friend, Zach. He can be my friend and your friend too. All right, everyone. Thank you for hanging out with us this afternoon. Thank you, as always, to everyone who watches until the very end, and we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe